Chapter 12. Writing Exam Answers. As Chapter 1 explains, law school exams are different from those you've encountered in other educational settings. You can't guarantee success simply by memorizing and parroting back a great deal of material, nor will elegant writing substitute for careful and critical analysis. Here, then, are some specific steps you can take to enable you to use the skills that got you into law school and the hard-earned legal knowledge you've gained since to achieve better exam performance. Tip #6. Carefully read the exam instructions and follow them to the letter. In the world of law school exams, some rules are made to be broken, and some rules aren't. Learning to tell which is which may be crucial to successful exam performance. On the one hand, a classic type of law school exam question is designed to test your ability to know when and how to break a legal rule you've studied by offering a hypothetical in which a seemingly straightforward application of the rule will lead to results that are utterly at odds with the rule's underlying purpose. By contrast, the rules stated in law exam instructions, e.g. page or word limits, should never be broken. Here's why. The stuffy toughie may actually enjoy penalizing you. As you might expect, different professors will react to violations of exam instructions in different ways. If your professor is what we call a stuffy toughie, someone who demands that each student to come to every class meticulously prepared, who conducts a relentless Socratic inquiry in a rigorous and highly formal manner, and who seems to take great delight in squeezing an extended analysis out of even the most reluctant student, chances are that he will take the same extremely demanding approach to grading your exam. Although we have always suspected that this sort of classroom style is largely a pathological byproduct of partner envy, stuffy toughies no doubt believe that what they are doing in the classroom will best prepare you for the rigors of legal practice. At least when it comes to demanding strict adherence to exam instructions, they have a point. Absent prior permission from the court for good cause shown, real-world judges and court clerks routinely refuse to accept pleadings and briefs that don't meet in every respect the applicable requirements governing, e.g., page length and format. And to our knowledge, no court anywhere has ever ruled that "I didn't know about the page limit," or "I didn't have time to read the rules," or "I just forgot" constitutes good cause shown. The stuffy toughie who is trying to prepare you for a career in which carelessness may harm a real-world client isn't likely to accept excuses like these either. The nice giggle may agonize over it, but will probably penalize you too. It would be a serious mistake to assume from what we've just said that a professor who runs a kinder, gentler classroom will look more kindly or gently on a failure to follow exam instructions. For one thing, virtually all law professors, from the most conservative curmudgeon to the most easygoing liberal, from most traditional black-letter teachers to the most postmodern theory of theory folks, take very seriously the task of preparing their students for the rigors of law practice. There is more than a little bit of the stuffy toughie in all of us, and the student who fails to follow rules that are as straightforward as most exam instructions is highly likely to bring it out. Our own experience leads us to make a second point here. Many students seem to think that, when push comes to shove, the nice giggle won't have the heart or the guts to penalize a student for something as picky as a failure to follow exam instructions. Truth be told, they're on to something. Many professors we know, and almost all of those whom we like, would rather walk over a bed of hot coals than lower a student's grade on what seems like a technicality. But here's the rub. For every student who just can't seem to follow our instructions, there are 24 others who take the time, and it takes time to read, to grasp, and to follow them meticulously. You don't have to be in law teaching very long to come to the conclusion that letting the few get away with careless mistakes penalizes the many who strive hard for compliance. And when it comes to a choice between excusing the careless and penalizing the industrious innocent, you'll find that stuffy toughies and nice guysgles quickly end up in the same place. Even if you don't lose points, you'll make a terrible impression on the grader. A law professor faced with grading 100 or more sets of blue books is a little like a law student attending a first-year orientation party with 100 or more of his or her new classmates. First impressions make a big difference. And the stronger that impression, the less likely it is that further and closer examination will change it. Naturally, this can cut two ways. When a professor reads an exam that begins straight off with a thoughtful and well-organized argument, she is likely to be more willing to resolve doubtful points in the student's favor later on. But when the first thing a professor notices about an exam is that it doesn't conform to the exam instructions, she is likely to get the impression that the student in question was either too careless to read them, too thick-headed to understand them, or too arrogant to follow them. While redemption is always possible in the end, nothing beats a good answer. No matter how it is packaged, persuading the grader you've provided a thoughtful analysis of her exam questions will be an uphill battle if she is already persuaded that you simply ignored her exam instructions. When in doubt, go find out. What should you do if you've read the exam instructions and you don't understand them if, for example, you genuinely think that there is more than one way to read a particular direction that the professor has given? E.g., does the page limit for Blue Book answers apply to typed exams? Our first and best advice is for you to take a deep breath and read the instructions once again, for the answer you seek may well be right in front of you. Most experienced professors develop boilerplate instructions that they use on exam after exam, and chances are pretty good that any real ambiguity would have been discovered and resolved years ago. But shocking though it may seem, even law professors make mistakes, and if after a second reading you still think the instructions are ambiguous or unclear, then for heaven's sake ask someone. The best place to start is with the proctor, but at many schools, the professors are available during the exam precisely for the purpose of dealing with unforeseen difficulties like these. Indeed, you may be doing both the professor and your classmates a favor by raising the point at a time when the professor is still in a position to clarify the matter for the entire class. If you are not able or not permitted to make such an inquiry, then we recommend handling the problem the way a good lawyer would. At the very beginning of your Blue Book, briefly identify the ambiguity you see and explain why you've handled it the way you have. If you've spotted an unintended ambiguity, the professor may well be impressed by both your careful reading and your cool under fire. But even if you've merely imagined the problem, the professor will be able to see that you are trying to follow the instructions, and most will appreciate that. An ounce of prevention is worth a pound of cure. As we said a moment ago, most professors develop boilerplate exam instructions that they employ with little change for each exam they give. As a result, there is no better way of familiarizing yourself with a particular professor's exam rules than by studying her old exams, particularly those she's given in recent years. See tip #4. Review the professor's old exams. Likewise, some professors distribute exam instructions during the final class of the semester, or during a review session, and do so for precisely the purpose of clarifying unintended confusion and ambiguity in advance of the final. If your professor gives you this sort of heads up, you should obviously take advantage of it. Tip #7. Read each question carefully and answer the question asked. When we told our friends and colleagues in legal academia that we were working on this book, 99 out of 100 of them responded that the single most important advice we could give you is this: answer the question. It was tempting to reply that maybe our students prefer to do as we do rather than as we say, for it is a common complaint that professors, especially the most relentlessly Socratic ones, seem to take great pleasure in doing everything with student questions except answering them. But given the stakes, we doubt that the typical failure to answer the question asked is the result of a rebellious attempt to turn the tables on the teacher. Moreover, given the obvious facility of most of our students with exams, you wouldn't be in law school if you hadn't done pretty well as an undergraduate and/or on the LSAT. We also doubt that the problem lies in your ability to answer exam questions. Instead, we think that the most common problem is that students misunderstand what it is that our questions are asking. Here are some brief suggestions for how to avoid falling into this trap. Read each question carefully and at least twice. We've all been there before. It's the final exam in the course that's been giving you trouble all semester. The proctor reviews the instructions and then signals the start of the test. You begin reading the first question, which is a complex factual scenario that goes on for a dozen paragraphs over two single-spaced pages. You've read about halfway through the question when you are distracted by a familiar, but in this context most distressing sound. 101 pens and pencils writing and scratching away furiously. "Oh no," a little voice in your head exclaims. "They're all already busy racking up the points, and you're the only one in the entire class who is still reading the question. You'd better stop reading and start writing right now, or you won't stand a chance." While the sense of panic is a common and even reasonable response to the stress of the exam setting, you simply must find a way to ignore that little voice, because the surest path to failure is to heed its advice. Simply put, you can't possibly answer the question asked unless you know what that question is, and it will take even the most gifted student 2, and sometimes even 3, extremely careful readings to gain the necessary purchase on what we're asking. Of course, you shouldn't overdo it. The point is to understand the question well enough to answer it, not to try to commit it to memory. And obviously, you need to leave yourself adequate time to write, since grades are based on what's in your blue books, not what's in your head. But pay no heed to those around you who have rushed through the reading and are already filling their blue books. A one-page answer that directly addresses the question we've asked is worth far more than a dozen pages of unresponsive blather. And in our experience, the race for superior grades is won far more often by the conscientious turtle than by the careless hare. Not every question is an issue spotter. The classic law exam question is the so-called issue spotter, i.e., the extended factual scenario that broadly invites the student to discuss the legal issues raised by the facts. Faced with such a question, the soundest strategy may well be to throw in everything but the kitchen sink, i.e., to identify and, to the extent time permits, analyze any and every plausible legal issue that you can uncover. But many of the exam questions you'll encounter in law school are not nearly so open-ended. Even issue spotters frequently restrict you to an analysis of the rights and liabilities of specifically identified parties. For example, a complicated torts question may feature a cast of more than a dozen, but ask you to discuss the legal rights of only Betty and Colin. Other common kinds of questions ask you to analyze a particular legal issue. Does X have a valid claim for adverse possession of Blackacre? Or to respond to a specific legal argument. If Y claims that evidence of those prior negotiations is barred by the parole evidence rule, how might Z respond? Students who've learned to use the kitchen sink strategy for open-ended issue spotters may have great difficulty shifting gears to cope with narrower and more specific questions such as these. But an answer that discusses the rights of Aaron when the question restricts you to Betty and Colin, or that analyzes the broad implications of consideration doctrine when the question focuses on parole evidence, will persuade the grader that you didn't read the question she labored long and hard to draft, or that you didn't understand it, or that you are simply unable or too stubborn to answer it. When she grades such an answer, it's safe to say that she won't come up with what you were looking for either. Avoid the information dump. If you were successful as an undergraduate, it probably means that you developed a facility for absorbing vast quantities of information and giving it all back on the final. And since your success as an undergraduate helped you get into law school, you might reasonably expect that law exams would require and reward a similar form of regurgitation. Indeed, that expectation is frequently reinforced by second and third year students who tell their junior colleagues that the thing to do on the final is to show the professor you understood the course. But once again, the thing to do on the final is to answer the question asked. And the student who ignores the question asked and responds instead by giving it all back, we referred to this in Chapter 1 as the information dump, will get nowhere fast. Don't fight the question or re-argue points already settled. One of the first lessons you learn in the law school classroom is to take nothing for granted, for the clever professor can take a judicial opinion that is seemingly focused exclusively on, say, whether a child can intend a battery and unearth a host of questionable assumptions made by the parties and the court, e.g., perhaps no one questioned whether the victim's horsing around with a child just prior to the battery constituted consent. But this is yet another lesson that can get you in trouble on a law exam. Thus, if an exam question states that it has established B's liability for breach of contract and asks you to calculate the resulting damages, you would be making a serious mistake if you tried to reopen the question of liability in your answer. At best, you will waste precious time by trying to prove a point that the question has already settled. At worst, you will fight the question and conclude that B is not liable to A, and thus that the professor's question regarding damages is beside the point. To be sure, there is always the chance that you are right, that the professor has made a mistake, and will reward your careful reading of the facts and perceptive conclusion. See Fact Hash 5. What if you think the professor has made a mistake? But 99 times out of 100, it is the student who has made the mistake by fighting, rather than answering the question the professor has asked. In a pinch, push harder, but don't BS. Of course, sometimes the reason that a student doesn't answer the question asked is that she doesn't know the answer to the question asked. Our advice here: push harder and harder on the question, and resist the growing temptation to talk about something else. If, for example, you read a question on your torts exam, and you aren't sure what the issue is, let alone what to do with it, you should reread the question, slowly and carefully, and then work your way back through your outline for the course until you figure out something pertinent to say. But the very last thing you should do is draft a lecture on the history or the deep philosophical underpinnings of tort law in the hopes that something you say will stick or impress the reader. The professor will know exactly what you are up to and is likely to give you a far lower grade for your efforts than the student who at least attempts, however unsuccessfully, to grapple with the question asked. See Tip Hash 22. Don't BS. Tip Hash 8. Organize an outline before writing your answer. It takes unusual self-discipline to refrain from writing long enough to organize your thoughts. But it's well worth the effort. Law school exams, like most mental puzzles, are easier to understand if you break the problem into steps. Suppose you are planning a trip to 3 foreign cities over 12 days, and your best friend asks you for a preview. You might start out by listing your plans for each day of the trip. Well, on Sunday we'll do this. On Monday that, etc. But your friend would find it much easier to follow if you started by saying something like, "My trip will last 12 days, 4 days each in Rome, Paris, and London." Then, as you moved into describing your itinerary for Rome, your friend would have a context to understand the trip as a whole. Better still, you'd have an easier way of remembering your plans. Precisely the same advantages stem from outlining your exam answers. You can quickly hit the main points and place sub-issues under their correct categories. This is much easier to do before you actually begin writing. We know that you're under a great deal of time pressure to begin writing, and that you won't get any credit for things you consider while outlining and then forget to include in your answer. See Tip Hash 10. Explain your reasoning. But virtually every professor prefers an organized essay, and outlining in advance is the best way to provide one. Outlining keeps you focused on the main ideas. Few aspects of law school exams are more daunting than the lengthy hypothetical with many characters, many events, and even more legal issues. It's tempting to feel that unless you plunge right in, you may not have time to discuss everything. The problem, of course, is that even if you do plunge right in, you still may not have time to discuss everything, and you may find yourself devoting 30 minutes to the issue that happens to pop into your head first. You simply can't afford to let the question bully you like this. Instead, take a few moments to consider the big picture. What are the 3 or 4 most important issues? Can other aspects of the question be grouped as sub-parts of these issues? Jot down a quick outline to this effect, and then begin writing. Your outline will assure that your answer is well organized and that you take time for the key issues. Outlining helps you think sequentially. A second major virtue of outlining is that it will force you to consider the proper order in which to take up the issues. Every question has its own internal logic that makes it easier to take up certain issues first. For example, if the plaintiff's standing is at issue, you might analyze standing at the beginning of your answer because the case cannot proceed without it. Outlining your answer won't guarantee that you will find the best sequence. But you are a great deal more likely to choose well if you pause to think before writing, rather than just diving in and discussing issues at random. Outlining helps you avoid wrong turns. One way in which sequencing turns out to be very important is that the resolution of some issues makes other issues less pressing, sometimes even irrelevant. On the first read of a lengthy issue spotter on your torts exam, for example, the causation issue may scream out at you for lengthy discussion. But careful outlining may lead you to conclude that negligence is the appropriate standard by which to judge the defendant's conduct, and that the defendant most certainly was not negligent. If that analysis is correct, then the question whether the defendant's action caused the plaintiff's injury is immaterial. You should certainly still flag it, partly to rack up points for issue spotting, but even more to hedge your bet in the event that your analysis of the negligence issue turns out to be wrong. But if you're right, and if your pre-outlined focus on causation had made you miss the negligence issue, then you would have done poorly on the question, even if your discussion of causation were first-rate. In short, outlining can help you to avoid getting sidetracked on issues that seem interesting at first, but turn out to matter less when you've thought the answer all the way through. Outlining helps you draft a roadmap. In the end, your goal is not merely to think through the answer, but to let your professor in on all that thinking as well. And your answer will accomplish that task far more efficiently if it begins with a couple of sentences explaining the major issues you will discuss and how they may fit together. Your outline, therefore, won't merely help you in your own thinking as you begin writing. It may also serve as the basis for an introductory paragraph that puts the entire question into perspective. In short, it will help you keep the forest in mind as you begin telling your professor about the trees. Tip #9. Provide the reader with a brief roadmap. There's no better way to get an exam answer off to a good start than with an opening paragraph that sets forth clearly the issues you plan to discuss. This assures the reader that the main issues will be considered and signals the order in which to expect them. Some questions will be so short that no introductory roadmap is necessary, and in that setting, drafting one may even needlessly slow you down. Never underestimate, however, the power of an introductory paragraph that confidently begins, "In this essay, I will consider the following 3 points." Create a strong first impression. Suppose your professor is reading and grading an essay answer on a property exam. The question instructs students to discuss 3 theories the plaintiff can use to seek access to defendant's land. One thing you can be sure of is that a regrettably large number of students will spend all their time on only one theory, and that some won't discuss the prospects for plaintiff's access at all. Consider then how happy your grader will be when she encounters an opening paragraph that begins like this. Plaintiff can seek access to defendant's land based on 1. The common law right of access to public places. 2. A statutory right to access on the ground that defendant has discriminated against her as a woman. And 3. A constitutional right to access for purposes of exercising her state-protected free speech rights. Whatever comes next, this student will have already established her ability to answer the question directly and to have identified 3 plausible theories. First impressions like this are extraordinarily important. It's true, you can make the same points by discussing Theory 1 before you even mention Theory 2 or 3. But consider the advantage of signaling the professor who is reading your analysis of the first theory that the rest of what she's looking for is on its way as well. Put ideas in groups. An introductory roadmap is even more helpful when there is a long list of things that you plan to discuss. As your professor reads through your analysis of 9 different issues, she may not even remember issue #3 by the time she finishes reading issue #8. You can help her out quite a bit simply by listing issues 1 through 9 at the beginning of your answer. But you can do even better than that by finding some way to break the 9 items into smaller subgroups. Consider the fact that most people remember Social Security and long-distance phone numbers not by committing 9 or 10 individual digits to memory, but by dividing such numbers into 3 smaller groups. You can take advantage of this form of information processing if you can find a way to use subgroups in your roadmap. For example, I will discuss 1. The justiciability of the plaintiff's case, where issues of standing, mootness, and ripeness are the relevant sub-issues. 2. The merits of plaintiff's equal protection claim, where consider in turn plaintiff's claimed loss of a fundamental right, his membership in a suspect class, and his victimization at the hands of an irrational government. And 3. Plaintiff's due process claim, where I analyze first the plaintiff's claim to a property interest, the supposed benefits of an earlier hearing, and finally the government's claim it needs to act with dispatch. Note that this approach goes a long way toward organizing the ensuing argument for the reader, leaving her less likely to get lost in the details. And little tricks like using all capital letters to distinguish the major groupings from the sub-issues may also prove helpful. Organize your own thoughts at the beginning and the end. Another advantage to an opening paragraph that provides a roadmap is that it encourages you to stop and think before writing. See tip #8. Organize an outline before writing your answer. You can't write an opening description of what you plan to say unless you have thought through your answer all the way to the end. And once you are finished writing, you can go back to the initial roadmap and use it as a checklist to see if you have covered all the points you listed as important. You may, however, find it enormously difficult to provide a clear roadmap as you begin your essay. Only after wrestling the key issues to the ground will you know for sure what the main points are. In that case, simply leave a blank space at the beginning of your exam and draft the roadmap after you have written the rest of the answer. As it happens, this is the technique many attorneys use, adding a summary of the argument only after they have finished writing the body of an appellate brief. But even if you add it after the fact, drafting the roadmap will force you to think about the question from a big picture perspective and help you present your answer as a well-organized whole. Tip #10. Explain your reasoning. No matter how many rules you know or how insightful your analysis, you get credit for only what you actually write in the pages of your blue books. It is therefore crucial to reduce to writing the thought process that leads you to your conclusions. In mathematics, you have a chance of getting the right answer through the wrong reasoning. In chess, you might make the correct move without understanding why. But in law, an answer is useful only if those expected to follow the law can be made to understand why that result was reached. And it is a principal function of lawyers to develop explanations to clarify the law in this way for judges, for clients, and for the public at large. You seek entry into a profession in which explanations will form part of your stock in trade. Your professor will demand that you start giving those explanations now. Explain to show what you are thinking. Legal conclusions are often based on chains of reasoning with many links or steps. Even if you reach the end result that corresponds to the professor's own conclusion, your answer will be incomplete unless you show just how you got there. Consider a hypothetical statute that you are asked to analyze on your constitutional law exam. After some careful thinking, you conclude the statute violates the Equal Protection Clause. So you write, "The Equal Protection Clause has been violated," and you go on to the next question without further explanation. Reading such a response, your professor will have no way of knowing why you see an Equal Protection Clause violation, and she is likely to grade you down, even if she agrees with your conclusion. For one thing, she'll want to know what level of scrutiny you think the court should apply to the statute. If your answer is strict scrutiny, she'll want to know the basis for that argument. Are we dealing with a suspect classification? Has a fundamental right been violated? Moreover, she'll want to know what justification you think the government will put forth to support the statute, and why you think that justification is insufficiently compelling. This is not simply another case of professorial pickiness. If you went to court to defend an equal protection claim, the judge would ask you about all of these issues, and the bald assertion that the Equal Protection Clause has been violated without some further explanation would do little to advance your client's cause. Likewise, a bald assertion on a law exam is unlikely to persuade the professor that you've mastered the course material. The more reasoning you show, the better you'll do, so go for it. Explain to help your analysis. A major advantage of working hard to show your reasoning is that it will help you improve your understanding of the question. Everyone has had the experience of making up his mind and then changing it after discovering problems during the course of attempting to defend the original position in writing. As you force yourself to articulate each step in the reasoning process, you give yourself a chance to question each part of your conclusion. For example, if in defending the view that the Equal Protection Clause has been violated, you force yourself to explain in writing the government's interest in the challenged statute, you might discover a more compelling interest than you initially realized. Similarly, on a contracts exam, if you try to marshal the facts that support your initial conclusion that a material breach has occurred, this effort might help you to spot circumstances that suggest substantial performance, and thus cut the other way. In short, explaining your reasoning is the best method you have for spotting the weaknesses and omissions in your own thinking. Best of all, as you begin to see the strength of the positions you have rejected, you're likely to feel a greater need to explain why you reached your conclusion and rejected other alternatives. See tip #12. Argue both sides. Only if you carefully spell out your reasoning from beginning to end will you have solid grounds for confidence in your conclusions. Explain to counteract mistakes. As we've said, you will do poorly if you reach the right answer, but don't explain why. Imagine then how your professor will react if you reach the wrong conclusion and provide no accompanying explanation. Since she can't read your mind, and the only thing you put in writing was wrong, you are unlikely to get any credit at all for your answer. On the other hand, since most professors are more interested in the quality of your explanation than in the correctness of your conclusion, they're likely to give you substantial credit for even a wrong answer that is accompanied by a cogent, if ultimately unpersuasive, argument. Indeed, since most law school exam questions present issues that could fairly be decided either way, you are likely to be safe with whatever conclusion you reach, whereas you are sure to be penalized if you fail to explain your reasoning. That's another reason it's silly to be fearful about putting your cards on the table. Make your assumptions explicit. Your thinking about the facts of the question is just as important as your thoughts about the law. If you argue that a federal statute preempts a state statute because it would not be possible to comply with both simultaneously, be sure to explain why, as a practical matter, you think simultaneous compliance is impossible. If you conclude that a contract is voidable because one party was a minor at the time of signing, say so and explain what facts lead you to this conclusion. Making your assumptions explicit in this way may help you spot ambiguities in the problem that you missed when you first read it. Thus, you may have initially concluded that the plaintiff was a minor because he read comic books and rode a skateboard. Yet as soon as you write this down, you'll realize that some adults do these things. Even if you don't catch mistakes, making your assumptions explicit will ensure that your professor can follow your reasoning. And that's the first step toward top-flight performance. You have nothing to lose. Even after reading all this, many of you will still want to hold back. After all, you figure that you are more certain of your conclusions than of the reasoning that got you there. The more reasoning you write down, the greater the chance the professor will catch a mistake and discover that you don't know what you are talking about. Why not just take the best guess you can about the ultimate outcome and hope the professor will be charitable and fill in the blanks in your favor? Because it won't work. You can't get away with conclusory answers because for the vast majority of questions you will encounter in law school, the professor cares far more about your reasoning than about the conclusions you draw. See tip #18. Avoid conclusory answers. Even a poorly reasoned answer most likely won't hurt you anymore, and it may hurt you a lot less than an answer with no reasons at all. So you might as well take a shot at providing the well-reasoned answer the professor is looking for. That's what law exams are all about. Tip #11. Draw conclusions when they are called for. Many law school exam questions end with queries like, if Johnny sues Jill for breach of contract, who will prevail and why? Such questions may cause a sinking feeling in the pit of your stomach. You believe Johnny has a strong case, but you see defenses for Jill that might be successful. In truth, you're just not sure who will win. Congratulations, you're on the right track. Odds are that the professor drafted the question precisely to generate such confusion. Do not, however, let your uncertainty cow you into silence about the outcome. If your professor has asked for a conclusion, The surest route to a disappointing grade is to fail to provide one. Our advice: give the professor your best judgment about the right result, while at the same time explaining why you are ultimately unpersuaded by arguments that cut the other way. In the end, you'll have to bite the bullet and embrace one side or the other. Use life, not school, as your model for dealing with difficult decisions. Many of you remember high school and college exams in which you were asked to solve a series of equations, or to remember the precise date of a famous battle. Even if you couldn't quite calculate or remember the answer, you saw the need to venture a guess because there was no substitute for the correct response. Law school exam questions that pull you simultaneously in opposite directions generate an understandable instinct not to reach any conclusions. After all, you have been trained to see what's wrong with each of the options that seems to be available. Such thinking, however, remains stuck on a vision of exams where you are graded down harshly for mistakes. Think instead about Hamlet's uncertainty, to be or not to be. As your model of tragic error, you wouldn't fail to make a decision affecting your future simply because there was virtue to more than one option. You may, for example, have had to decide whether to attend a private law school or a less expensive state university. Either decision might have turned out to be a mistake. But attending neither because you weren't sure which was best would certainly have been counterproductive. Law school exams that ask for conclusions frequently pull you in opposite directions like this. Draw conclusions to improve your analysis. The greatest virtue of forcing yourself to draw conclusions is that it requires you to ask yourself hard questions. Your professor may have drafted a question for which there is no ready answer. On a property exam, for example, the language of a document may suggest that the grantor intended to place restrictions on the property, but the general rule abhorring forfeitures may suggest that the document is too ambiguous to create restrictions. You'll probably do well on the exam by spotting and explaining the contradictory interpretations. But if the question asks for a conclusion, you must force yourself to decide whether this is a case where the grantor's intent or the rule against forfeitures should take precedence. This will force you to describe the reasons behind each rule, and to take a stab at which set of reasons seems more compelling under the precise facts given. Perhaps the forfeiture would be particularly severe, or alternatively perhaps the grantor's intent should take priority because the grant was a gift to charity. Only by pushing toward a conclusion can you get beyond mere boilerplate recitations of the competing positions. Say yes to one, but don't leave the other behind. The fact that a question calls for a conclusion means it's not enough to describe the strengths and weaknesses of both positions, however eloquent your descriptions. But don't be lulled into the opposite error of embracing one conclusion and ignoring the very strong points that point in a different direction. See tip #12, argue both sides. A conclusion isn't well drawn unless it adequately explains why opposing positions were rejected. So as you make your case, be sure to explain not only why you chose the result you did, but also why you rejected alternatives. Watch your emphasis on reasons vs. results. Any professor who asks you to draw a conclusion will be annoyed if you decide instead to merely recite pros and cons. Indeed, some professors will find this thoroughly unacceptable. As always, you should pay careful attention to such preferences, and thus heed your own professor's take on the need to reach decisive conclusions. See tip #14, remember who your judge is. The same is true when it comes to emphasis. All professors will look at your reasons and your results, but what may vary is the emphasis individual graders will place on each. In general, we recommend that you never draw conclusions without reasons, and that you worry more about reasons than results. But we also urge you to pay special attention to what's expected by your grader and determine the appropriate emphasis accordingly. Tip #12. Argue both sides. Law exists to resolve conflict through peaceful means. Accordingly, every legal problem begins with an actual or potential disagreement between people. When a client walks into your office to tell you a story, you will always hear about some other person whose views and interests may differ from your client's. Good legal advice will follow only if you can grasp the problem from your client's point of view. and from her potential adversary's perspective as well. Indeed, the capacity to see and argue both sides of a case is perhaps the most important intellectual skill you will develop in law school, and so you can't expect to pick it up by reading a brief tip, however brilliantly it is written. To be sure, we do have a lot more to say about this skill. Parts I and Roman II of this book are an extended treatment of how to go about seeing and arguing both sides on a law exam. But what we'll tell you here is that your professors have struggled hard to invent questions that present a real challenge, and they will be disappointed if you seize on some facts and arguments, while ignoring others to reach a quick, one-sided conclusion. Instead, start by following these steps to ensure that your exam performance doesn't end up disappointing you as well. Consider each person's perspective. The best way to ensure that you argue both sides is to imagine how the loser might respond to your initial sense of how the case should come out. If your first instinct is that Johnny is liable to Jill because he obviously breached their contract, ask yourself what Johnny would have to say. Why didn't he deliver the widgets on time? Perhaps he thought they didn't really have a deal. Is there any basis for this view? Perhaps he thought Jill was supposed to call to confirm her order, or that they had additional details to work out, or that his obligation depended on some contingency that had not occurred. The point is that in the real world, there are almost always two sides to a story. On a law exam, you can virtually count on that to be the case, and for good reason. To be sure, clients call on lawyers to help them with routine situations in which the rights and obligations of the parties are clear-cut and utterly unambiguous. But law school would be unworthy of its label as a professional school, let alone of its place in a university, if it did not also help you to confront the more complicated situations in which both parties may rightfully lay claim to some version of law and justice. Your task is to show just how each side would do so. Seize on contradictory facts. Contradictions make many people uncomfortable. If you were reading a novel and the main character is described as generous on page 27 and stingy on page 115, you might conclude the author was asleep at the wheel. We all recognize that people have contradictory characteristics, but we'd at least expect the novelist to try to reconcile them, e.g., by explaining that our hero was usually generous, but stingy when it came to his own children. On law school exams, however, you should treat apparent contradictions as cause for celebration. Suppose Dennis grants his neighbor Wilson what the parties term a perpetual easement to use Dennis's driveway for Wilson's wheelchair-accessible van. This part of the document makes it look like Dennis intends the easement to last forever, and that it will thus be available for use by the next owner of Wilson's home who also wants access to the adjacent driveway. Suppose, however, that the same document begins with the words, "Because you, Wilson, are injured and need access to the driveway, I, Dennis, hereby grant you," etc. This part of the document makes it look like Dennis wants the easement extinguished if Wilson moves away. If you were drafting the document, you would do your professional best to avoid such ambiguities. But if you were drafting an exam response to the problem of whether the new owner of Wilson's home can use Dennis's driveway, you should be laughing your way to law review. That's because you have a fact that will help you argue Dennis's position that the easement is extinguished, and you also have a fact that will help you argue Wilson's position that the easement runs with the land. Facts that send conflicting signals like these are exactly what you need to do well on your exam. Instead of ignoring or hiding from them because you find them confusing, you should search them out and exploit them for all they're worth. The professor struggled to invent them. She will be delighted when you highlight and illustrate the contradictions, and awfully disappointed if you don't. Use tensions in the law to your advantage. The way law pulls you in different directions takes some getting used to. Law embodies conflicting ideals like liberty and equality. Different jurisdictions have different rules, and sometimes it's hard to tell whether, for example, state or federal law applies. Even case law is famously riddled by questions of which precedent governs. Each of these tensions may feel like an obstacle to overcome. Who wouldn't wonder which rule really does apply? Which ideal should take precedence? Or even simply which prior case is controlling? But on an exam, Each of these tensions is in fact an opportunity to demonstrate your mastery of the topic. If it appears to you that one important case supports a decision for the plaintiff, while another equally controlling case suggests a decision for the defendant, just say so, instead of throwing your hands up in despair. You are far more likely to be rewarded for spotting both points of view than you are to be graded down for your failure to reach a conclusion in which you can be 100% confident. After all, law is a human invention designed to resolve an extraordinary range of human conflict. How could we expect it to produce simple answers in such a complex world? Find something interesting in the question. Once upon a time, you took exams that asked you straightforward questions like, name the state capital of Florida. Tallahassee was worth 10 points. But if a law professor were drafting that geography exam, she would be far more likely to complicate matters considerably by telling you that a legislative task force has decided that the state capital must be relocated and has asked you, as its chief counsel, to draft a memorandum identifying the most desirable alternative site. An answer like, the capital of Florida should be Miami because it's the state's largest city, has the advantage of coherence, but it lacks depth. It would help if you were to add that it makes sense to have the capital be the state's largest city because today's global economy demands concentration of financial, political, and human resources. But your answer won't get interesting until you can identify a second theory that rivals the first. Maybe the capital should be Orlando, since it's more centrally located and citizens have a right to easy access to the seat of government. Only when two plausible rival theories have been identified can a productive debate occur and an interesting analysis emerge. So too, when law professors draft law exams. For every question you read, you should ask yourself why the professor found this particular set of facts interesting. What are the competing understandings of or approaches to the case that caused the professor to ask about this fact pattern rather than another? For example, if a question about landlord-tenant law involves a live-in babysitter, the odds are pretty good that the professor is interested not only in a straightforward application of the landlord-tenant rules, but also in the big-picture question of whether those rules should apply in this unusual setting. Most professors will be looking for you to present the case for the routine application of the rules, as well as the case for a special live-in babysitter exception, so that you can demonstrate an awareness of the choice to be made and the pros and cons of each approach. Arguing both sides, then, is a technique that can help you to remember that law is about choices, and that hard choices make the most interesting exam questions. Tip #13. Stick to the facts and circumstances presented. We know it's annoying to receive seemingly contradictory messages from your professors. Be creative, we say. Show some inventiveness, some imagination. And then as soon as you start strutting your stuff, we turn around and plead that you stick to the question at hand. But you really can satisfy both demands, as long as you keep the following points in mind. Analogize, don't digress. Perhaps the most common form of legal analysis is the analogy. This case is like that case, we argue, and therefore this case should be decided the same way that one was. Indeed, if the two cases are enough alike, the argument from analogy even gets its own fancy Latin name, stare decisis. As a result, the ability to identify analogous cases and situations is a vital skill on law exams as well as in legal practice. Never forget, however, that the point of an analogy is to help you resolve the problem at hand, not to show off how much you know about some other situation. Let's say, for example, that you get a property exam question about parents who want to fire their live-in babysitter. The sitter claims that as a tenant, she can't be evicted from the parent's home. She argues that her poor job performance was effectively a withholding of rent to protest the failure of her live-in quarters to comply with the warranty of habitability. You may recall that the New Jersey Supreme Court faced an issue of whether to treat workers as tenants in State v. Schuck, 58 NJ, 297, 277 A2D 369, 1971. Your professor will be impressed if you note that the court in Schack found a way to permit migrant farm workers to receive visitors without granting the workers tenant status. This might suggest it will be hard for the sitter to succeed in making that claim here. but your professor will be annoyed. If once you raise shack, you spend 3 pages detailing the facts of that case, explaining how the case fits in with general issues involving the rights of owners to exclude, and how it illustrates a judicial tendency to avoid constitutional issues. The professor wants to know about the babysitter's rights, not about state v. Shack, and you shouldn't lose sight of that. Be careful with the word if. Make up your mind which issues in the question are meant to be ambiguous and worthy of discussion on the one hand, and which are presented as clearly settled on the other. For ambiguous situations, the word if is important, even essential. You will often find yourself writing sentences such as, if the grantor is found to have intended that the covenant run with the land, then the new owner won't be able to violate the restriction. Here your biggest concern is to make sure that where the question makes the grantor's intent unclear, you discuss how and why the court will be likely to resolve this ambiguity. See tip #10. Explain your reasoning. In many cases, however, certain aspects of the question will be entirely clear. There may be a contract dispute between two experienced business persons who obviously fit the definition of merchant under the Uniform Commercial Code. You may be very proud of yourself for knowing the rule for non-merchants, and therefore tempted to throw in a dangerous sentence such as, if the parties were not merchants, then the rule would be thus and so. Or the plaintiff in an equal protection suit may be a white male. You are still feeling the thrill of learning the categories whereby equal protection suits are judged differently when brought by women or African Americans. You wonder how it could hurt to throw in sentences with beginnings such as, if the plaintiff were an African American. If phrases like these could hurt a lot. When the professor writes a question about merchants, she wants an analysis of merchants, and of course you should point out that you are applying the merchant rule. When the professor makes the plaintiff a white male, that's the situation he wants resolved. If you aren't careful, your professor's reaction may be something like, if you had stuck to the facts and circumstances of the question, you might have done very well. Invent solutions, not scenarios. It is one thing, and generally a good thing, to invent multiple ways that a court or other decision maker might respond to the set of facts presented in your exam question. You can do this well by considering various theories of liability or different remedies a court might impose. It's entirely another thing, and one you should stay away from, to invent ways that courts might respond to sets of facts that are different from those presented in the question. You might have a brilliant theory for how a court should handle the scenario in which a tenant is evicted for engaging in union organizing. But if the tenant in your question is evicted because his kid writes on the walls, that's the scenario you should discuss. Don't write treatises about the law. The most common form of departure from the facts and circumstances of an exam question is the flight into generalized statements of law. Such poor answers start off on the right foot. You read the question and draw a correct view of the legal issues involved. So, for example, you might observe that a dispute between neighbors over a loud radio could give rise to a nuisance suit. At this point, however, having spotted the nuisance issue, you launch into a lengthy discussion of the definition of nuisance and a description of all the nuisance cases covered in the course. This discussion wastes valuable time and takes you away from the facts and circumstances presented. You may know a great deal of nuisance law, but the professor wants to hear only the parts relevant to the question at hand. Tip #14. Remember who your judge is. Your law school exam is intended for an audience of one: the professor who will grade it. This is not wholly unrealistic preparation for law practice, where you will frequently find yourself trying to persuade a particular decision maker, such as a trial judge. But for better or worse, law students have only one person to please. Don't forget these tips for doing so. Follow your professor's advice. No matter how much time we spend writing about exam excellence, this is the most important advice we can give you. Listen carefully to every word your professor says about what she wants in an exam and try to provide it. If your professor tells you that she cares most about your listing the elements of a cause of action, then forget everything you read either here in these tips or elsewhere in this book and list those elements. Your professor is in charge of your course, and it's your job to prove you can play by her rules. And in case we haven't said it often enough, the clearest instruction your professor gives you on every exam is the language of the exam question itself. Pay close attention to the way the question is phrased and what the professor is looking for. Follow those instructions to the absolute best of your ability. See tip #7. Read each question carefully and answer the question asked. Think about your professor's style. It's dangerous to leap too quickly from superficial characteristics to a professor's exam preferences. Thus, your professor might arrive every day in a suit and tie or a fancy dress, yet be relatively relaxed when it comes to what's expected in terms of writing style on the exam. It makes most sense to listen to what the professor actually says she wants. There is nonetheless something to be gained by attempting to draw some exam lessons from the nature of the course. If every day's class is spent on refining the holdings of cases, it's safe to assume the professor cares a lot about your ability to do so. If the professor cares in class about mastery of detail and gives a closed book exam, then you'd better be careful throwing around details you don't quite remember. If a professor appears very interested in policy arguments, then you should find a way to work them in. And if a professor appears to value in-class creativity, then keep your imagination humming from beginning to end on exam day. Look for course topics and themes. The increasing amount of material covered in law school courses makes it difficult for everything from your course to be tested on the exam. Nonetheless, if your constitutional law class spent 8 weeks studying the Commerce Clause, and you read over the exam and can't find it, read the exam again. It's unlikely your professor would have chosen to spend half a course on something unworthy of testing. Equally important, if your professor stresses certain themes such as the role of the states as laboratories for government experimentation, look carefully to see if that theme has resurfaced on the exam. Law school courses vary. Some emphasize a steady diet of rules, while others hunt for an organizing principle or a set of themes. Ask yourself how your professor has approached the course, and make sure to see if you can approach the exam the same way. Disagree freely, but knowledgeably. Occasionally, a professor will ask a more open-ended policy question that asks you to draw a conclusion about an issue you have studied. Suppose, for example, your property teacher asks whether rent control should be abolished. One fear you may have is that your professor's liberal pro-tenant views may conflict with your position that rent control is counterproductive. Get over it. The overwhelming majority of professors are happy to read exams that disagree with their position. Your exam-taking concern should never be which side of an argument you are on, but only on what you have to say to support your side. Keep the level high and the pace fast. We can't stress enough the tedium that your professors experience in reading answers to the same questions over and over and over again. Every time you repeat the facts, see tip #17. Don't repeat the facts or revert to stating the law without applying it, see tip #16. Don't regurgitate legal rules and principles. You slow the professor down and risk annoying her. Get to the point as fast as you can and spend most of your time on the issues you find challenging. It may seem counterintuitive, but it will pay off. A sense of humor can help. Let's be clear. You want above all to stick to the point and stay within the bounds of propriety. If you are tempted to make a joke and in doubt about whether it's in good taste, don't do it. That said, if you find easy ways to throw in a little humor, by all means do so. Your professors often work hard to place a few amusing diversions in the exam questions. Perhaps the character names on the exam come from a recent hit movie or TV show. Letting us know you noticed or giving us a chuckle won't rescue a bad exam. But at the margins, it certainly can't hurt. Tip #15. Watch time credit allocations. Most law school exams are time pressured, some quite drastically so. Accordingly, your professor is unlikely to be impressed if you write solid answers to 2 of the 3 essay questions and handle the third one with a big, bold, out of time. It's virtually impossible to score well if you receive no credit for an entire question, and there's no reason this should happen to you. Here are some ways to avoid it. Put your agony on paper. All of you are accustomed to doing very well on exams, and most are accustomed to exams in which knowing the answer is the key. Because law exams demand analysis, not answers, there's an understandable tendency to freeze. The question asks whether the plaintiff has standing, and you're genuinely not sure. You see a strong case that the plaintiff is injured in fact, but you're not sure the defendant is the cause of the injury. Odds are that your uncertainty is the result of a question that the professor has deliberately drafted to invite more than one plausible conclusion. If you write down why you aren't sure, you'll probably be doing very well. But even if you really are a bit confused, you'll do much better writing something than nothing. The key here is that genuine uncertainty about the legal result is exactly what the professor hopes to create. If that uncertainty makes you feel bad, writing down why is your best revenge. Adopt a speedy style. Consider the chess concept of tempo that stresses executing your plan with sufficient speed to finish before your opponent completes hers. This means, for example, that if you are trying to move your pieces into the center and trying to defend pieces your opponent has threatened, it's great to find a move that simultaneously defends and develops a piece in the center. The law exam equivalent is to learn to write with sentences that accomplish several things at once. Thus, there's little advantage to a writing style that begins by listing various components of a legal doctrine and then proceeds to analyze them. Compare a slow style response to a fast one for a hypo involving a lawsuit by a presidential candidate defeated by a 34-year-old who fooled the public by forging his birth certificate. Slow. The Supreme Court in Allen v. Wright identified 3 factors to determine whether a plaintiff has standing. 1. Has the plaintiff suffered injury in fact? 2. Is the defendant's injury caused by the defendant's conduct? And 3. If the plaintiff prevails, can the court provide a remedy that will adequately redress plaintiff's grievance? Under the first factor, we see that the plaintiff has suffered an injury because he lost the presidential election to a 34-year-old and hence ineligible candidate. Under the second factor, plaintiff has greater difficulty because he may not be able to show that the fact that the winning candidate was underage caused the plaintiff to lose the election. The third factor is also problematic, because even if the court were to disqualify the underage candidate and seek to remove him from office, the court would not be able to install the losing candidate in the White House fast. There's no question about the plaintiff's injury. He lost the election to an ineligible candidate. So the real problems with establishing standing involve proving causation. There's no guarantee plaintiff won the election due to the forged birth certificate. And showing redressability, the court clearly can't install the plaintiff in the White House. The fast answer has tempo because it combines a demonstration of knowledge with an analysis of the problem rather than attempting to perform these tasks separately. Force yourself to move on. There's not much more to say than that. If you have 10 more points to make about question 2 and only 30 minutes left, do you think those 10 points will help you more than spending the same 30 minutes on question 3, which you haven't even begun? If you've been writing about question 2 for an hour, odds are you have already covered the main points. If you haven't, spend 5 more minutes on a quick outline of these points and move on. Outline when you must. You can't do as much with an outline as you can with a clear, crisp essay. But you can do a lot. 2 good outline answers are likely to put you much higher on the curve than 1 great essay and 1 big blank space. To outline, merely identify the issues you'd discuss in full if you had the time. One neat trick is to list the factors that might push you to one conclusion or the other. For example, one clear issue here is whether the plaintiff has standing. For standing, against standing, injury, clear causation, doubtful, clear legal question. For court, hard to see, court, redress, plaintiff, clearly not a bystander. An outline like this may earn you some much needed points. But beware. Some professors refuse to read answers that aren't written in prose, and virtually all of us prefer an essay. So while this strategy can be enormously useful, you should employ it only in a pinch.